Good day, sir. My name is LLJ Galiusa Talion. This is my video for final exam in CLG 400 Section B. Define evidence and explain its scope. Evidence is the main sanction by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact, and its scope is the rules of evidence shall be the same in all courts, in all trials and hearings except as otherwise provided by law or these rules. So second, what are the three kinds of evidence? Briefly explain each. So object as evidence are those addressed to the scenes of the court when an object is relevant to the fact in issue. It may be exhibited to examine or viewed by the court. Second, documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray, films, motion, pictures, or videos. Testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Third question. Distinguish corroborative evidence from cumulative evidence. So corroborative evidence is additional evidence of a different kind and character tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point. This is purely the accumulation of similar evidence that is derived from common sources. Fourth question. What is prima facie evidence? Prima facie evidence is the evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor to the issue it supports. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party that offers the prima facie evidence. Fifth question. What is a dying declaration? What about statements uttered as a part of the risk state? Dying declaration, the declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his or her death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. So the statement uttered as a part of the risk stay are as follows. So first, there is a starting occurrence. Second, the risk stay act or declaration is about the starting occurrence. Third, the risk stay act or declaration is spontaneous. So 6, what is the order of the examination of individual witnesses? Briefly define each. So order in the examination of an individual witness, the order in which the individual witness may be examined is as follows. So A, direct examination. Direct examination is the examination in chief of a witness by the party presenting him or her the facts relevant to the issue. So B, so cross-examination. Its purpose and extent upon the termination of the witness may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias or the reverse, and to elicit all important facts bearing upon the issue. So C, redirect examination. Its purpose and extent after the cross-examination of the witness has been concluded. He or she may be re-examine the party, calling him or her to explain or supplement his or her answer given during the cross-examination. So the letter D, cross-examination. Upon the conclusion of the redirect examination, the adverse party may cross-examine the witness on matters stated in his or her redirect examination and also on such other matters as may be allowed by the court in declaration. So 7th question. Briefly explain what is a judicial affidavit. So a judicial affidavit is a statement of a witness given under oath intended to take the place of their testimony in court given during examination. So 8th question. An offer of compromise in criminal cases is an implied admission of guilt. What are the two exceptions? So first, in quasi-offenses or act defined and penalized under Article 365 of the Revised Penal Code. Second, those allowed by law to the compromise. Their usual examples are found in the Revised Penal Code, particularly Article 266-D of the Revised Penal Code, or if a compromise was made before the filing of the criminal complaint. 9th question. In order for evidence to be admissible, it must be relevant and competent. When evidence relevant? When is evidence competent? The court look into the characteristics of the evidence and check if these characteristics of the evidence and check if these characteristics satisfy the criteria for admissibility. If these do, then the court admits the evidence into the case record and will consider it when making the judgment. 10th question. What is a leading question? When is it allowed? A leading question is a question which suggests to the witness the answer which the examining party desire. He is allowed on cross-examination on preliminary matters when there is difficulty in getting direct and intelligible answers from a witness who is ignorant, or a child of tender years, or is of feeble mind, or a deaf mute, of an unwilling or hostile witness or agent of a public or private corporation, or of a partnership or association which is an adverse party. So 11th question, what is a misleading question? A misleading question is one which assumes as true a fact not yet testified to by the witness, or contrary to that which he has previously stated. It is not allowed. 12th question, when is circumstantial evidence sufficient to sustain a conviction? Evidence is circumstantial when there is a need to make a logical inference that leads to the main fact. If the unbroken chain of events proved by circumstantial evidence is combined, the courts can decide on the fact in issue. So 13th question, distinguish burden of proof from burden of evidence. So burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shifts. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish prima facie case. Burden evidence may shift from one party to other in the course of the proceedings depending on the exigencies of the case. So 14th question, what is the standard proof necessary in civil cases, criminal cases, and administrative cases? So preponderance of evidence. In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. Preponderance of evidence. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. So 15th question, define what are public documents. The provision above enumerates the kinds of documents considered as public by the courts for evidentiary purposes. They are public by reason of publication or making them known to third persons or the general public. 16th question, how do you prove and present in court private documents? A private documents is typically only known and binding between or among the parties. However, when the private documents is notarized, it is converted into a public one, and it serves as a notice to the public that the documents exist and that the parties have executed such document. The notarized documents therefore carries with the badge of authenticity, because no person would make a document known to other person unless he or she intends to the bound by the terms and conditions stipulated in the documents. 17th question. The original documents rule states that when presenting a document as evidence only the original is admissible. What are the 4 exemptions? So original documents must be produced. Exemptions: when the subject of inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence is admissible other than the original document itself. 18 question. Who can become a witness? All persons who can perceive and perceiving can make known their perception to others may be witnesses. 19 question. When is an extrajudicial confession sufficient to sustain a conviction? Confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. So that's all my video for final exam in CLJ 400 section B, and have a nice day and God bless us all.